Good morning, everyone, and many thanks to Professor Trujillo for inviting me to contribute to this interesting summer school on legal interpretation and human rights. As you know, the topic of my intervention is a fairly specific one. I deal with the Kurdish question in Turkey. Essentially, it's a case study of group accommodation in the context of international human rights law. By Kurdish question, obviously, I mean the set of questions relating to the accommodation of Kurdish rights following the partition of Kurdistan after the collapse of the Ottoman Empire. At the end of the First World War, as you know, the Kurdish community scattered throughout 4 states, Turkey, Iraq, Iran, and Syria. And half of them actually live in Turkey, so clearly accommodating the position of the Kurds in Turkey is a pretty significant political and legal challenge. And over time, the Kurdish leadership has developed ideas about this, starting, of course, with the first articulations of what used to be called, and is still called, the democratic solution to the Kurdish question by Öcalan, the historical leader of the Kurdistan People's Party, the PKK, but also more recently, over the past few decades, pro-Kurdish political parties have emerged and have debated, discussed and endorsed models of accommodation, including the focus of my analysis, which is the so-called democratic autonomy proposal and its consistency with international human rights standards. So in that sense, the focus is not on Turkey's human rights obligations per se, although the analysis mirrors largely Turkey's international legal position. It's more about the conceptual consistency and coherence of the democratic autonomy proposal in light of human rights standards, particularly internal self-determination in Turkey. That is the focus of my analysis. This is part of an article that is being published as we speak, and of course I'm more than happy to circulate the paper as we proceed to all of you, or those of you who may be interested in taking a look at it. It is not an article, it is not an analysis based on self-determination per se. It is more about looking at the Kurdish argument through the lens of human rights law, in particular reference to self-determination. The Kurdish argument is, of course, a way of capturing or seeking to capture the gist of the Kurdish position, regardless of whatever variations might exist within the Kurdish movement. Of course, when these variations are significant, I tend to single them out in the analysis. What is the structure of my piece? Well, I look at the Kurdish argument first and then assess it against the international legal context, and I do this in 3 steps. 1, by looking at the conceptualization of the Kurds in international law. Secondly, by looking at the substantive human rights categories that can be seen as a background to the Kurdish argument. And finally, by discussing the implications of that background for internal self-determination in Turkey. So essentially, I look at democratic autonomy as a case of internal self-determination in Turkey. So first, what is the position of the Kurds and what do they want, basically? By democratic autonomy, they mean to refer to a number of things, essentially 3 ideas. 1, in a certain idea of community. 2, a certain idea of democracy, and 3, a certain idea of autonomy. By community, basically, they mean a group of people who are defined by a common mindset, and this mindset is largely defined by pluralism, internal pluralism, and self-government on a both individual and collective level. Yes, they have a strong sense of identity, but this identity essentially does not result in either proposing a culturally homogeneous entity aspiring to become a nation state and therefore challenging the existing boundaries of states, nor does it propose an ethnocentric model that rejects the internal diversity of the community. It is what Öcalan and others and subsequent pro-Kurdish political leadership have defined as a democratic nation, a nation which is fairly pluralistic within. And that is connected to the concept of democracy. Democracy is quintessentially about popular control over decision making. In this particular context, it's more about emphasizing the existence of a political regime that allows for the self-expression of groups, in particular that allows the Kurds to take an active part in decision-making processes short of a Kurdish state. So in other words, the point is not, or the focus is not on the creation of a Kurdish state, but rather on opening up political processes that can allow a genuine pluralistic approach to the accommodation of the Kurdish community and other minority groups. So in that sense, democracy speaks to the democratization of Turkey, the democratization of Kurdish societies, and even to a level of coordination of Kurdish activity across national boundaries, particularly in terms of what has been referred to as democratic confederalism, so a way of coordinating Kurdish entities based in the various states in the Middle East, and therefore amplifying their voice and leverage, both within and outside and beyond state boundaries. Autonomy is the key concept because it basically speaks to an internal form of accommodating Kurdish demands. And there are two layers to it. One is the recognition of group identity, essentially through a process of constitutional restructuring. Here the focus is mainly on language and education rights. And secondly, the introduction of elements of self-government that can, again, be instrumental in the protection of Kurdish interests. Now remember, most Kurds live in southeast Turkey, but not all of them. There's still a significant number of them who live in western Turkey, Ankara, Istanbul, and so on. So unsurprisingly, there's a tendency to combine territorial with non-territorial solutions. But in either case, the focus is on grassroots participation, civil society networks, and of course, an additional institutional level provided by the evolution of power, decentralization of decision-making authority, eventually self-government. So essentially, when we look at the proposal as a single package, we see that there are at least three overarching objectives. One is identity recognition for the Kurds and other minority groups, the other institutional reform, the third one, some form of enhanced rights protection for all that essentially gives space for a hybrid approach to issues of belonging, for instance, communal respect, societal intersectionality, and so on. How does this proposal play out in the context of human rights standards? I do this by looking at three elements. One, the conceptualization of the Kurds as a people or a nation. Everybody knows that the Kurdish community has a strong sense of identity that persisted and survived the fragmentation of Kurdistan at the end of the First World War. Now, unsurprisingly, this strong sense of identity has fueled claims to national self-determination. And of course, the classical question will be whether the Kurds constitutes a people for legal purposes. Now, if we look at the idea of a nation from this point of view, if you look at the idea of the Kurds as a constitutive nation, as a co-founding nation of the Republic of Turkey, as some sectors of the Kurdish leadership we want to see in a revised constitution, it is pretty clear that international law may be a rather reluctant bedfellow, in the sense that the notion of a Kurdish nation appeals or can be traced back to the idea put forward by US President Wilson of national self-determination at the end of the First World War as an attempt to combine national or political nationalism and cultural nationalism, democracy and group identity. The fact of the matter is that if you look at what has happened across much of the 20th century, considerations of group identity in this context have been consistently subordinated to considerations of territorial stability. And the upshot of this has been a certain ambiguity by the international law, a certain ambivalence by international law, by international adjudicators in particular, towards the characterization of a particular community as a people for legal purposes. The reference case is a classic example of that ambiguity. As you know, the Supreme Court of Canada had been asked to comment on whether Quebec was entitled to unilateral secession under either Canadian law or international law. Now, in the context of a broader discussion about self-determination, they conceded that self-determination could benefit only a part of the population. They conceded that self-determination was normally fulfilled, it is normally fulfilled through internal arrangements rather than territorial changes in sovereignty, and yet they insisted on the notion that determining whether the population of Quebec constituted a people for legal purposes, or even a people amongst other peoples within Quebec and wider Canada, was not necessary. And I used the reference case to make an important distinction between convincingly and successfully articulating an argument about peoplehood in international law and acknowledging and dealing with the coexistence of sub-state national claims as part of the legal process. In effect, what the court did was to find a constitutional duty on the parties to negotiate, to sit around the table and discuss, in response to what they saw as a legitimate sociocultural reality, the position of a significant sector of Quebec society, and they need to achieve, or they quest for achieving, some level of distinctiveness within and possibly outside of Canada. There are other examples where adjudicators avoid the question of whether a community represents a people for legal purpose, and yet recognize a variety of entitlements and possibilities of accommodating their position within the state. So in essence, I draw on this practice to argue for a flexible way of articulating Kurdish claims through a variety of forms of legal and institutional recognition, along a continuum that spans from individual rights, individual circumstances, to robust forms of self-government. So in other words, an integrated view that assumes the legitimacy of the Kurdish community as a socio-cultural reality and then intervenes on the basis of a variety of tools provided by international human rights law in terms of group accommodation, where it's general human rights, no minority rights, or ambitious forms of self-determination. What are the substantive legal categories that somehow relate to the Kurdish argument? This flexible positioning of the Kurdish argument ties up very well with the main key categories that seem to play a role in this context. Clearly, the internal focus derived from the lack of a unilateral right to secession or independence. We know that the principle of territorial integrity is a classic legal and policy mantra in all relevant international legal instruments, even those who do not explicitly refer to the right to self-determination. Think of the declarations of minorities, indigenous peoples, among many others, who are clear that nothing in those texts can be seen as a way of allowing for the disruption of national unity, the territorial integrity of the state where the group lives. The alternative possibilities of extra constitutional processes or even remedial secession appear to be rather shaky in terms of international law support. Yes, there might be some level of recognition following, but again, normally an extra constitutional process would not receive any particular support from third states in international law. Remedial secession doesn't seem to have received a strong backing from the international community so far. So again, the focus has to be on internal processes, and that means essentially focus on democratic processes, pluralism, effective participation, and ultimately a link to internal self-determination. These are the categories that I outline in my article, particularly in terms of prohibition in international human rights law of any arbitrary restrictions by the state on the possibility of group self-identification and self-expression. Of course, that self-identification and self-expression has to be combined with some plausible socio-historical evidence appropriate to the case. The method with which the claim or claims are made has to be a non-violent one. And thirdly, has to be compatible with the rights of individuals within and outside the community. But generally speaking, international human rights law recognizes this minimum baseline from which any assessment in terms of pluralism and the tolerable level of pluralism within society has to be conducted, has to be measured. Effective participation is another important category here, both in terms of general voting right and participation rights, for example, the ones set out in Article 25 of the ICPR, and in terms of more specific forms of institutional accommodation, autonomy on a territorial and non-territorial basis. There are also transnational dimensions that could possibly be attached to participation, either in terms of activism, transnational mobilization through representative organizations, or even in terms of more ambitious forms of transnational jurisdiction with a public law dimension. Of course, the latter opportunity, the latter possibility is a very peculiar one, and frankly, examples here are few and far between. Those very few tentative cases that we might consider, that I mentioned in the article, normally presuppose an advanced level of regional cooperation on a governmental level, and or a regulator role for a keen state. More importantly, whatever degree of pluralism or participation is achieved for the group, that should not be seen as a stepping stone towards secession or independence. And here again, we come back to the importance of a mutual accommodation between the parties, between majorities and minorities, in order to make sure that there is a proper balance between separation and social cohesion. In the article I mentioned, for example, the OSCE Ljubljana guidelines on the integration of diverse societies that make precisely that point, a process of mutual accommodation based on effective participation. And that chimes very well with an evolving account of internal self-determination as a dialogical process, a relational process that aims at providing some form of recognition for well-established sub-state group claims. And of course, this process is driven, in my view, by at least three elements. One, the group's ability to articulate its own claims, the availability of a set of justifications for particular forms of accommodation, like self-government, and thirdly, a set of operational issues that are likely to arise from the implementation of self-government, particularly the rights of individuals, the respect for the rights of individuals, and the role of the state. And this is what I do essentially in the second half of my piece, when I look at democratic autonomy as internal self-determination, as a case of internal self-determination in Turkey. First, on pluralism participation, I argue that, again, the focus has to be on the restructuring of Turkey and Turkish society, rather than the establishment of some form of constitutional framework that can operate across the Middle East. Transborder autonomy is important, but doesn't seem to be a constitutionally viable solution across jurisdictions, as opposed to private law-based networking activism. In other words, it is one thing to say that Kurdish NGOs or Kurdish associations based in different states can interact with one another and amplify their claims at international level. It is quite another to call for the simultaneous entrenchment of a regime of self-government that can operate across jurisdiction with a public law dimension. So, to the extent that the focus has to be on Turkey in this case, or the jurisdiction of a particular state, I make 3 points. One is that whatever we make of the notion of the Kurds as a democratic nation, certainly a degree of self-identification must be respected regardless of state, of the state's position. And this, in my view, is or can be supported by custom international law. In other words, it doesn't really matter how they define themselves, provided that there is an empirical basis for it, plausibility for it, and other requirements are met, such as non-violence and so on. In terms of pluralism, I would argue that pluralizing Turkish society is probably more important than recognizing the Kurds of a distinct people for legal purposes, precisely for the reasons that I mentioned earlier. If you compare the hybrid blend of ethnic and civic nationalism put forward by the Kurdish leadership and compare it with the rather ambivalent attitude of international law towards cultural nationalism, it seems pretty obvious that acknowledging the Kurds as a people for legal purposes is less important than opening up a constitutional process for the democratic autonomy proposal to be given serious consideration and recognition. And finally, participation has to be addressed within a state framework. The emphasis of the Kurdish leadership on non-state participation, on non-state self-government, can be understood as a discursive strategy for achieving eventually a genuinely pluralistic framework that can empower the Kurds in the political process. But in the end, if you look at the Kurdish argument from a human rights perspective, you cannot do away with the state framework within which that proposal needs to be addressed. And there are at least 2 or 3 dimensions that have to be considered. First of all, the participation in the electoral process. As we know from the criticism coming from international human rights bodies, more recently the UN Committee on Racial Discrimination and other bodies, the exceptionally high threshold to gain representation in Parliament, 10%, has historically inhibited or impacted or affected the ability of pro-Kurdish parties to be represented in government, despite a significant level of Kurdish support. Of course, that means that there is an immediate link between the internal process of pluralization and general participation rights as set out in Article 25 of the ICPR. Secondly, freedom of association, the associative platforms that are necessary for the Kurds to be able to articulate their claims must be respected. Now, this seems to be an obvious point to make, but as we know from the news, this is not something that can be taken for granted in modern Turkey. Finally, the element of self-government. This element requires a more complex set of considerations. It doesn't automatically derive from participation rights, although, of course, self-government can be seen as a fairly advanced form of participation. And this is what I examine in a separate section, the level of justification for democratic autonomy. And I make here 3 or 4 points. One, there is a good and solid historic background that justifies the distinctiveness of communal existence, of Kurdish existence, but also the consistency of the Kurdish claim to autonomy. The Kurds used to enjoy autonomy in certain areas, with Diyarbakir, Raqqa and Mosul as their respective centers, at least beginning in the 16th century. Those autonomies varied, were eventually abolished as a result of the process of forced assimilation by the late Ottoman elites. The same process was then taken up by the Kemalists in the early 20th century. The 1921 Kemalist constitution was not in itself hostile to Kurdish autonomy. In fact, there was an article in the constitution, Article 11, that promised a provincial, a law on provincial autonomy. That provision was never implemented, but in fact one of the purposes was precisely to accommodate Kurdish demands at a time where Ataturk was calling upon the Kurds to support the war of independence in the early 1920s. All of that, of course, went out of the window once the war was over. Lausanne definitely breaks away from Sèvres, 1920, that promised a scheme of local autonomy. But in effect, Lausanne does not in itself explicitly prohibit autonomy solutions, or indeed an exemption of the minority concept. So if you look at all this element comprehensively, you can still say that at least on an empirical level, there is an element of consistency in the Kurdish argument that automatically applies to the international law framework as well, in the sense that recognizing autonomy would not be would not go against this particular background. Not only that, but I think that the historical background is also capable of engaging with international law self-determination more directly. First of all, in conditions of sustained conflicts like the present one may reasonably argue that autonomy is probably the best way or the only way of implementing existing norms of internal self-determination. And this has been recognized in a variety of conflict scenarios where political rivalries and rival identities are such that a degree of separation is absolutely necessary. Not only that, but autonomy would go, we would essentially help correct injustices produced by the abandonment of the Sèvres arrangement in 1920 and the reshaping of the Kurdish question as a matter of forced assimilation. Now, obviously, the Kurdish question cannot be addressed merely as an issue of intertemporal law, so we cannot apply the subsequent law of self-determination to facts that occurred at a much earlier stage, but to the extent that the effects of those unequal policies are still being felt in the present, we can reasonably argue that the evolving norm of self-determination can and should apply in a way that Lausanne can no longer be seen as a valid platform for sort of insulating the Kurdish question from international human rights law, from contemporary human rights standards. Finally, the resilience and long-standing articulation of Kurdish demands should be seen as a trigger for a proper self-determination process in line with the reference case. Remember, in the reference case, there was an emphasis on the need for a clear majority of the inhabitants of Quebec to be in favor of secession. Now, this by analogy can be applied to autonomy claims, precisely because of the same democratic and legitimacy related logic. In that sense, Turkey has to respond to this clearly expressed view by virtually all sectors of the Kurdish movement over time, in line with participation standards and with the wider objective or mutual accommodation. Finally, in terms of operational issues, I don't want to say too much here because not all of what I argue is directly relevant to this discussion, but essentially there is a need for striking a balance between a process of regionalization of the country that has been called for by the Kurdish movement itself, and the hyper-localistic approach to Kurdish areas that essentially is based on sub-regional autonomy that basically starts at a street or village level and goes all the way up to higher levels of provincial and regional government. International standards do not rule out any specific form of autonomy, regional, sub-regional, although when it comes to group accommodation, normally the focus is on regional rather than sub-regional. Autonomy with municipal administration or self-administration being seen in the context of particular towns or territories or in connection with particular forms of cultural self-government. So in that sense, a careful balance needs to be struck. But the more important point from a human rights perspective is one that whatever form of self-government is achieved, that should not be seen in the context of an exclusively Kurdish administration, and this has been made clear by the Kurdish leadership itself, in the sense that they have made clear that any form of self-government must involve the respect of the rights of all inhabitants of Kurdish areas, including the rights of other minority groups, and this has been the practice of current civil society networks operating along the lines of what the democratic autonomy proposal seems to require. The other point is the role of the state, because again, despite the emphasis on the non-state element of self-government participation, the state is still key to not only securing rights, but also making sure that individuals are protected within communities. Ideally, they should also be encouraging pluralism within communities, but certainly they should be operating as the last port of call for the rights of individuals within particular self-governing unit. So in the end we can say that there is a good mix of elements that engage more or less effectively with international human rights law. For example, there's a shift to internal processes away from secession. There's an important emphasis on political and cultural pluralism. There's a good historical record of autonomy practice that can be linked to contemporary standards of internal self-determination. And there's an inclusive view of Kurdish populated areas such that the rights of all inhabitants, not only the Kurdish community per se, can be respected. More problematic issues arise from the democratic autonomy proposal when it comes to articulating an argument based on the national identity of the Kurdish as a people in a legal sense, and the possibility for that to be recognized in a revised constitution of Turkey. More radical forms of transnationalism that may face the challenge of a lack of intergovernmental cooperation at the regional level and the lack of a king state. Self-government as a municipal or village level localism that may or may not be achievable in the context of self-government for groups or in connection with group accommodation. And in general, the dynamic state, non-state narrative that is put forward by the Kurdish movement that sometimes may actually lead up to downplay the role of the state, not only in achieving rights, including self-government, but also in protecting rights within the communities. So the argument that I make here is that any future settlement of the Kurdish question will require not only Turkey's compliance with its own human rights obligations, but also the Kurdish movement's ability to negotiate a proper settlement, a proper accommodation of its own aspirations in ways that are consistent with international human rights law. And this is best done through continually adjustable rather than fixed institutional goals.